Hello, dear students. My name is Duba. I head the mocks team at Losico Test Prep, and I am here to conduct your Limitation Act quiz. First of all, welcome to your first quiz in the Madhya Pradesh Civil Judge series for mock tests for the prelims. Let me know how the mocks have been so far because I do, like I said, head your mocks team as well. So please let me know in the comments if you've taken the mocks. So far, we've had two. So, how were they? Just drop your views in the comments. I'll be able to see them. While we wait for a few other students to join in. I understand that this is a Saturday and things are a bit slow because you anticipate the weekend. All right. So just make sure you're leaving your answers to the quiz in the comments. What we will do here is I'll simply present a presentation wherein the questions will be asked on the screen and I'll read them out loud as well. What you have to do is to drop in your most probable answer and I will give you a timer for a few seconds to figure out what the answer can be. And then just afterwards, we'll reveal what the correct answer is. What this does is that it helps you recapitulate concepts and also train your answering speed, which is essential in your prelims. As we know, it is a timed examination. You don't have all day. We need to be very careful in answering the questions within the stipulated time period. If we're answering 100 questions, we need to make sure we are answering them within the correct time frame and the time limit. So we shall be beginning, and just let me know via your comments if you have any queries or if you want me to stay a bit longer on any single slide. So here we have, this is our first question. The first question is that every suit instituted, appeal preferred, and application made after the prescribed period shall be dismissed. Now, this is the question, and then it shall be dismissed when the first option is in which limitation has been taken as a defense. The second option is although limitation has not been set up as a defense. The third is in which limitation has been taken as a ground in the pleadings. And the fourth is although limitation has been set up as a defense. So, since the question is a bit long winded, most of the questions in limitation will be of a similar format. I'll stay on the slide a bit longer so that we get an opportunity to understand it. So every suit instituted, appeal preferred, or application made after the prescribed time shall be dismissed in which of these following circumstances. So what do we think is the correct option? You can let me know in the comments. Just let's try and take a guess. Just type in whichever answer you think is best. I'll begin the timer now. We have 5 full seconds to try and answer the question. And the correct answer is option number 2. Why? Because it shall be dismissed although limitation has not been set up as a defense. So, although even if limitation has not been set up as a defense, where the suit is instituted, the appeal is preferred, or the application itself is made after the prescribed time, the suit shall itself be dismissed. That is provided via Section 3(1) of the Limitation Act. Next question. When a suit is instituted in the case of a claim against a company which is being wound up by the court? Option number 1 is, I see a few of us trying to join in. Let's try. You didn't answer in the first question. Let's try and make an attempt to answering. Can I get to know your names, please? Just try and make a comment. You can add a comment where it says chat, and I'll be able to converse with you a bit. Just let me know who is there. That should be helpful. Yes, guys? Still no comments. Okay, so when is a suit instituted in the case of a claim against a company which is being wound up by the court? Is it instituted before the appointment of the liquidator by the court? Or is it instituted before the passing of the liquidation order? Or is it instituted where the claimant first sends in his claim to the official liquidator? Or is it instituted when the liquidator accepts the claim filed by the claimant? Which of the following can be the correct answer? Can we try and take a guess as to which is the correct option? So, when can a suit be instituted where there is a claim against a company, the company that is being wound up by the court? Excellent, guys. Okay, we're having more people join in now. That's good. Just let me know what you think is the correct option to the question here. The question is, when is a suit instituted in the case of a claim against a company which is being wound up by the court? Is it instituted before the appointment of a liquidator by the court? Is it instituted before the passing of the liquidation order? Is it instituted when the claimant first sends in his claim to the official liquidator, or is it instituted when the liquidator accepts the claim filed by the claimant? Excellent. Shivani thinks it's 3, when the claimant first sends in his claim to the official liquidator. With that, we will begin our timer, and we'll have the rest of us try to attempt an answer as well. Come on, guys, you have to beat each other to the timer. This is a competitive atmosphere. Shivani is correct. Why? Because Section 3(2) of the Act reads that a suit is instituted ordinarily when the plaint will be presented. But in the case of a company, we go to 3(2)(3), right? In the case of a company where there is a company is being wound up by the court, it is instituted when the claimant first sends in his claim to the official liquidator. That is the point of institution of the case. Next question. Which of the following acts as an exception to the extension allowed by Section 5 of the Limitation Act? So, what is an exception to the extension that is provided in Section 5 of the Act? Appeals an exception? Are judgments and orders an exception? Is the execution of decree an exception? Or is the application for stay an exception? What do we think, guys? Let's try and have an answer. We must know the answer already. Even if we don't, the worst that can happen is that we'll answer it incorrectly, in which case, within 5 seconds, we'll know the correct answer. So we have nothing to lose. Okay, Shivani, let's try and have another attempt. So, what acts as an exception to the extension allowed by Section 5? Shivani thinks execution of decrees. Okay, I have begun the timer. And that is Correct. Section 5 itself, again, as Section 5 provides the extension, but then it states that other than an application under any provision of Order 21 of CPC may be admitted after the prescribed period if the appellant or the applicant satisfies the court that he had sufficient cause for not preferring the appeal or making the application within such period. And what is dealt within with Order 21 of CPC? Execution of decrees and orders. So it is in itself accepting Order 21 of CPC, which contains execution of decrees and orders. Next question. Before a person's disability has ceased, he is affected by another disability. Then, now in the scenario, then he is bound to institute the suit between the two disabilities. So the period between disability 1 and disability 2, does he have to institute the suit in this time period? Or he is bound to institute the suit after the first disability is cured, or he may institute the suit after both disabilities have ceased, or none of the above. So, which of the following is mandated by law in case of a person with disabilities, where he has recovered from one disability, but then he is inflicted with another disability? So, what is the correct legal course of action per the limitation law? What shall be accepted for this person per the limitation law? Okay, Shivani thinks that he may institute the suit after both the disabilities have ceased. So Shivani thinks he has to wait for both the disabilities to dissipate and end. Asifa thinks that as well. I'll start the timer. Who else? Come on, let's make a few other attempts as well. And that is correct. Why? Because of section 6.2. So where there is a person at the time where you would calculate the prescription period where he is affected by two disabilities. He has one disability that has completely gone, then he's affected by another disability. He will be allowed to wait till both the disabilities have ceased. So that is the correct course of legal action here. Next, nothing in section 6 or in section 9 shall be deemed to extend for more than which period from the cessation of the disability? More than 2 years, more than 3 years, more than 5 years, or more than 7 years? Which of these could be the correct answer, guys? Asifa, Shivani, who else is here? Let's try and attempt an answer. Asifa thinks 3 years. So nothing in section 6 or in section 7 shall be deemed to extend for more than 3 years from the cessation of the disability. Asifa and Shivani both think that 3 years is the ceiling for the extension period. Let's see what the correct answer is. Any more guesses? That is right. Both Asifa and Shivani are correct. Section 8 provides for special exceptions, extending the reach of section 6 and section 7 of limitation. And it is stated that nothing in section 6 or in section 7 applies to suits to enforce the rights of preemption, or at the other hand shall be deemed to extend for more than 3 years from the cessation of the disability or the death of the person affected, right? So 3 years from the actual period of limitation, nothing can go further than that. Section 8 states this. Next question. A had to produce his appeal on 5/10/2002. So a bit of maths we require here. Let's keep our eyes sharp, our minds sharp. A had to produce his appeal on 5/10/2002. A reached the court at 2 p.m. He found that the court had closed due to the untimely demise of the judge by heartache. The court was open for half day on the same day, that is 5/10/2002. Can he file the appeal on 6/10/2002? Is it yes, no? Is it no specifically because the court was only open in the first half hours? Is it yes specifically because it was shut during the normal working hours and it was not his fault that the court had closed on the day of the 5th? Shivani, what do you think? Asifa? Is his putting up the file for appeal correct here? Okay, Shivani thinks he shall be correct in appealing on the 6th because he was not at fault, and that is correct. Why? This is the maxim of lex non cogit impossibilia. So law will not compel a man to do something he cannot possibly perform, right? And also actus curiae neminem gravabit. That means an act of the court shall prejudice no one. So it happened because of something that happened in the court, was out of the realm of possibility for the person. So as a collective action of both these maxims, the person is not at fault. Okay, Asifa? So the person is not at fault. So this falls within the scenarios performed or envisioned under Section 4 of the Limitation Act, and he again will be allowed to appeal on the next day because this was simply outside the scope of his control. Next question. Where letters of administration to the estate of a creditor have been granted to his debtor. So, administration of estate of a creditor, the letters are being granted to his debtor. The running of the period of limitation for a suit to recover the debt shall be what while the administration continues? Shall this running of the period of limitation be continued? Shall it be suspended? May it be continued? It may be continued, or it may be suspended, or is it none of the above? Asifa thinks it is suspended, that the limitation period for this while shall be suspended. What does Shivani think? Shivani thinks that as well. I've started the timer. Come on, there's more of us. Let's try and attempt an answer. That is correct, because Section 9, dealing with continuous running of time, provides that this exact scenario, that where letters of administration to the estate of a creditor have been granted to his debtor instead, the running of the limitation will be suspended for this time period. Ankita, you're correct as well. Moving on to the next question, whether whether the plea of limitation can be waived by a party. So, can the plea of limitation be waived by a party? Is that a right available? Is it yes? Is it no? Is it only possible after permission is sought from the court, or is it only possible where both parties have given consent for the same? Ankita thinks it's only possible when the court has given permission for the same. Excellent. Ankita, you've answered. Kanupriya thinks it is not possible for the plea of limitation to be waived. Shivani also thinks it is not possible for the plea of limitation to be waived. And I will begin the timer. Asifa, you have not answered, and that is correct. Option number 2 is correct. So, Section 3 makes a general declaration on the basis of public policy that no waiving away of this sort shall be entertained by the court, right? So, it's a mandatory provision. There is no waiving that is available, whether by the acquiescence of parties or other cases or by the granting of court. Limitation runs as a rule of law and it stays as a rule of law. Next question. Under Section 15 of the Limitation Act, exclusion of time is not applicable to which of the following? Is it not applicable to suits? Is it not applicable to appeals? Is it not applicable to application for the execution of a decree? Or is it not applicable to all of the above? So, all three of these it doesn't extend to. So, again, Section 15 of the Limitation Act, exclusion of time as envisioned under Section 15. What could be the correct answer? Kanupriya thinks it is not applicable on the cases of applications for the execution of a decree, where you apply to the court for the execution of a decree. I have started the timer now. Let's have the rest of us come on. We need to beat each other to the timer. Come on. The correct answer is 2 because of Section 15, right? Section 15 states that in computing the limitation period of any suit, the institution or execution of which has been stayed, whether by injunction or by order at that time, you have to, first of all, it states that the day on which this thing was done, it shall be excluded. Then subsection 2 provides that in computing the period of limitation for any suit of which notice has been given or of which previous consent or sanction of the government or any authority is required, or whether the law prescribes that any such authority provides that notice, the period of such notice again shall be excluded. And then in excluding that time for obtaining the seeking of that consent, etc., that day again shall, the other day, the day which the government is taking basically for answering, shall be included. So again, this is dealing with appeals. We answered with appeals. Yes, so Ankita is correct, right? So as we can see, just a moment, let me scroll to the. So as we can see, suits, again, you go to point number 3. It involves application for execution of decree. It as well is included. What is not included in here is an appeal itself. So execution of decree, suit, applications, etc., all are included. What is not included? The appeals are not included in here. So that makes 2 the correct answer. Whether the time taken by tribunal for providing certified copy of order will be considered while calculating limitation. Again, what will be included within the limitation period, what will be excluded from the limitation period. What is the correct stance on this? Is it that no, limitation is calculated from the date where the order is uploaded on the website? Is it no, because limitation is calculated from the date where order is pronounced by the court? Is it yes, because a certified, obtaining a certified copy is just as important? Or is it simply no because of reasons other than options 1 or 2? So again, is the time taken by tribunal provided for providing certified copies of orders considered while the limitation period is talked about? Ankita thinks no, limitation is calculated from the date when the order is pronounced by the court. What does Kanupriya, Shivani, Asifa, what do we think? I've started the timer. So the tribunals are taking time for providing certified copies. Shivani thinks no because of other reason. That is correct. The answer Ankita made was correct as well, but that was not the exact reason for saying no, right? So if you go to the case of Sanket Kumar Agarwal versus APG Logistics, the case of 2023, very recent, it went to appeal, and the Supreme Court stated that where we are dealing with, the tribunal, the certified copies, etc., we have to make sure that it is done within time, first of all, and it also had that for the purpose of computing limitation, whether it is in that particular case it was with regard to the IBC, the Insolvency and Bankruptcy Code, but it stated point blank that the time it takes for the tribunal to give us the certified copy of the order, it has to be excluded from the computation of limitation, right? So the simple reason is no, not because of the specific reason stated in option number 2. Now, period of limitation for suits relating to immovable property. Where is it found? The period of limitation for suits relating to immovable property. Is it provided in Part 5 of Division 1 of the Schedule to the Limitation Act? Is it in Part 6 of Division 1, Part 7 of Division 1, or Part 8 of Division 1? Again, this is relating to immovable properties, suits relating to immovable properties. Which part and division is it in? Kanupriya thinks it is in Part 6 of Division 1 of the Schedule of Limitation Act. Let's see if Kanupriya is correct. It is in Part 5. Shivani is correct. Not in Part 6, it is in Part 5. We are dealing with immovable property. So suits relating to immovable property, if we have to look up the period of limitation for them, we go to Part 5 of the first division of the Schedule of Limitation Act. In ordinary cases, the suit is instituted when the plaint is presented to whom among the following? When the plaint is presented to the court, when the plaint is presented to the proper officer, when the plaint is presented to the police officer, or when the plaint is presented to either the court or the proper officer over there. These are ordinary cases, and when the institution of suits begins. In ordinary cases, when does the institution of suit begin? Where is the plaint when the institution of a suit begins? Kanupriya thinks it is instituted when the plaint is presented to the proper officer. Asifa, excellent. Ankita, please answer as well. That is correct. Why? Because of section 3.1 states that 3.2 clause 1 that in an ordinary case the suit shall be deemed to be instituted when the plaint is presented to the proper officer. So the qualifying statement used there is presenting a plaint to the proper officer. Which of the following is not the ingredient or the ingredients to claim exclusion under section 14? So is it proceedings that relate to the same matter as the matter in issue? Is it there should be prosecution should be in good faith in a court? Is it that there should be a defect of jurisdiction, or none of the above? Correct. So which will not fall under the ground to claim an exclusion under section 14 of Limitation Act? Again, which will not fall? The question is asking you which will not fall under the grounds of asking for an exclusion to sections 14 of Limitation Act. Asifa thinks none of the above, which means Asifa thinks that all of these should be present in claiming exclusions. Kanupriya thinks the same. Good. These are things we need to pay attention to in the question. Is the question asking for positives, negatives? What is it asking for? That is correct. Why? Because exclusion under section 14 will be made where either the proceedings is relating to something that has been the same in the matter before, or if there is a prosecution in good faith in a court, right? Or if there is a defect of jurisdiction or some other defect of a cause because of which the court cannot simply take the case. So that means that none of the above were not in the exclusions. All of them were in the exclusions asked. Priyanka has joined us as well. Yes, Priyanka, that was correct as well. Excellent. The exclusion provided in 14.1, this is the next question. The exclusion provided in 14.1 is applicable on which of the following? So section 14.1 is providing us an exclusion which is applicable for, is it applicable for suits? Is it applicable for appeals? Is it applicable for revisions? Or is it applicable for all of the above? With the first answer, I'll start the timer. Kanupriya, excellent job. He has answered suits. What do the rest of us think? Come on, let's answer before the timer ends. The timer has ended. Come on, guys. And Asifa is correct. So 14.1, like I just read, in computing the period of limitation for any suit, the time during which the plaintiff has been prosecuted with due diligence, other civil proceedings, whether in a court of first instance or of appeal or revision against a defendant, shall be excluded, where the proceeding relates to the same matter in issue and is prosecuted in good faith. So the same exclusions we just read about, right? So this is dealing with first instance or of appeal or of revision. Next question. When the property over which easementary right is claimed belongs to the government, the period of uninterrupted enjoyment. So, uninterrupted enjoyment refers to what period? It shall be of how many years? Shall the uninterrupted enjoyment be of 20 years, 30 years, 25 years, or 10 years? I believe Shivani is answering one for this one. Is that correct, Shivani? Asifa is answering two. So Asifa thinks that the period of uninterrupted enjoyment shall be of 30 years. Kanupriya thinks 30 years. Shivani and Priyanka as well. We think 30 years. I'm wondering where Ankita went. That is correct because of section 25.3 states that 30 years should be the period of uninterrupted enjoyment. Earlier it used to be 20. Now the words 30 have been inserted. Limitation period for suits for arrears of land is how long? Is it 1 year, 3 years, 2 years, or 5 years? The limitation period for suit for arrears of land. Again, let's take a break to revise the schedule a little. Shivani thinks it's 3 years, so limitation period for suit for arrears of land. And that is correct. Article 52 within the schedule provides, that is, it is enumerated as Article 52, limitation period for suits for arrears of land. It is instituted within 3 years from when the arrears have become due. Now we are moving on to a question on adverse possession. Adverse possession, this was stated about adverse possession, that adverse possession can be used as a sword under Section 27 of Limitation Act when read with Article 65 of the schedule. Which case made this statement? Was it the case of Gurdwara Sahib versus Gram Panchayat of 2013? Was it the case of Ravindra Grewal versus Mankit Kaur of 2014? Was it both the cases that the court cited this view in, or was it the case of Kale versus Land Acquisition Collector of 2015? Let's have a few guesses. Let's have a few guesses come in, guys. Kanupriya thinks it is the case of Ravindra Grewal versus Manjit Kaur. I've started the timer. Priyanka thinks it's Gurdwara Sahib. Okay, excellent. And Ravindra Grewal's case is correct. In the case of Gurdwara Sahib, the case of Gurdwara Sahib's decision was overruled, in fact, in the Ravindra Grewal case. And in this, the court stated that, Article 65 of the Limitation Act has not only enabled a person to set up a plea of adverse possession, as a shield, as a defendant, but has also allowed the plaintiff, on the other hand, to use it as a sword to protect his possession of immovable property or to recover it in case he has been dispossessed. So the Ravindra Grewal case of 2019 is where this statement was made, and again, it also overruled the judgment of Gurdwara Sahib. Next question. Under Order 22, Rule 4 CPC, the limitation period to have the legal representative of a deceased plaintiff or appellant or of a deceased defendant or respondent made a party is. So, if you want a deceased person to be made a party, a deceased person's legal representative to be made a party in a case, what is the limitation period for this in case of Order 22, Rule 4 of CPC? Is it 90 days from the death of such a plaintiff, defendant, or whoever it may be? Is it 30 days from the death? Is it 60 days from the death? Or is it within 1 month from such occurrence of death? Again, we are focusing on making a legal representative a party where the actual party has died. So Shivani thinks it's 90 days from the death. Kanupriya thinks it is 60 days from the death, and Priyanka thinks that as well. And if we go to Article 120 of the Schedule of Limitation Act, we see that Shivani and Priyanka have answered correctly, and it is the limitation period for this is 90 days from where he has died. Whether it is the plaintiff we are talking about, the appellant, defendant, respondent, whoever, what we want is for the legal representative to step in, and we must act on making that legal representative a party within 90 days because of Article 120. Now, Limitation Act, a conceptual question on Limitation Act. Limitation Act is it lex loci? Is it lex fori? Is it lex principus? Or is it lex contractum? What is the nature of the Limitation Act? Yes, guys? I have begun the timer. All right. And it is indeed an ejective law. It is lex fori. So it is the law of the country where you're bringing the action. If you want to bring an action in a particular country, you must stick to the limitation laws of that country only. And it will only extend to the territorial extent of that exact country, which makes it lex fori. Section 8 of the Limitation Act limits the extension permissible by virtue of Section 6 to how many years? To 3 years, to 1 year, to 2 years, or to 4 years. So the extension that is allowed within Section 6, if you are paying attention, you must know the answer to this. We discussed this in an explanation to a previous question. So Section 8 of the Limitation Act limits the extension permissible by virtue of Section 6 to how many years? Kanupriya thinks that the limitation made has been to 3 years. Priyanka as well. Shivani as well. Excellent. And that is correct. Section 8 does indeed deal with special exceptions as we discussed before, stating that for these sections, Section 7 or Section 6, the rights of preemption, enforcing the rights of preemption within suits, no more than 3 years from the cessation of disability of a person or death of a person, the period of limitation may be extended. So no more than 3 years. What is the limitation period for any suit for which no period of limitation is provided elsewhere in this schedule? So what is the limitation period for a suit where no other limitation, where the limitation law is silent, the schedule of limitation law is silent? What do we consider to be the limitation period for such a suit? Is it 1 year, 3 years, 2 years, or 5 years? We must know this, a very easy question. Okay, Shivani thinks it's 3 years. Ganupriya as well. So where the schedule is silent, we go to 3 years because of Article 113, that wherever for every other case, it shall be 3 years. Limitation period for a suit of preemption is how long? 1 year, 2 years, 3 years, or 4 years? A suit for preemption. I have started the timer. Come on, guys. We must know this on the tip of our tongues. Preemption. Shivani thinks it is 1 year. And That is correct. Why? Because Article 97 deliberates on this, stating that the limitation period for a suit to enforce a right of preemption, whether the right is founded on law or on general usage or on a special contract, it is 1 year from when the purchaser takes under the sale sought to be impeached physical possession of the whole or part of the property sold. So, where he is taking possession, physical possession 1 year from that date, or where the subject matter does not admit of physical possession, when in those cases it happens within 1 year from when the instrument of sale is registered. So, from 1 year of registering instrument of sale or from 1 year of taking physical possession. All instruments under Limitation Act are deemed to be made in reference to which of the following? To the English calendar, to the Roman calendar, to the Sankhya calendar, or to the Gregorian calendar? Again, a question we must know the answer to. Come on, guys, let's attempt an answer in the comments. Kanupriya thinks Gregorian calendar, okay. Shivani as well. That is correct. Section 24 does deal with it, that the time mentioned for the purposes of the Limitation Act are made with reference to the Gregorian calendar. Priyanka is correct as well. What is the limitation period for instituting a suit for compensation for trespass? Compensation for trespass, what is the limitation period? 4 years from the date of trespass, 3 years from the date of trespass, 2 years from the date of trespass, or just 1 year from the date of such trespass? Come on, guys, let's attempt an answer. Shivani and Priyanka think it is 3 years from the date of trespass that we can institute a case for compensation for trespass. And that is correct. Article 87 does provide that such an action requires a 3 year limitation period. Within 3 years of such an occurrence, can you institute the case seeking compensation? Legal disability under Section 6 of Limitation Act can be by way of which of the following? Intoxication, infancy, penury, or both B and C? All right, we think Priyanka thinks it's both B and C. So both infancy and penury are understood to be legal disabilities as seen under Section 6 of the Limitation Act. What do the rest of us think? Come on, guys. And legal disability, penury is not one of these. Minority is, lunacy is, and idiocy is. Even intoxication is not referred to within the Section 6 of Limitation Act. What we deal with over there is minority. Again, let's remember MIL. Minority, I for idiocy, L for lunacy. All right. So these three forms of disability are recognized in Section 6. So not penury and not intoxication either. In computing the period of limitation for any suit, appeal, or application, the day from which such period is to be reckoned shall be excluded. This is provided under which section to the Limitation Act? Again, we must know this. Is it Section 12.1? Is it Section 12.2 that provides it? Section 12.3 or Section 12.4? The statement is written in the question. We just need to figure out which section it belongs to. Priyanka thinks it's Section 12.4. Shivani thinks 12.1. I have begun the timer. Come on, Kanupriya and Ankita, and Section 12.1 indeed is correct. It states that in computing the period of limitation for any suit, appeal, or application, the day from which such period is to be reckoned shall be excluded. That is in 12.1, not 12.4. Okay, Priyanka? 12.1 provides for this. Section 13 of the Limitation Act deals with which of the following? Does it deal with successful applications to sue as a pauper, unsuccessful applications to sue as a pauper, applications to sue as a pauper made in good faith, or does it deal with both 2 and 3? Come on, guys, let's try an attempt. Section 13 deals with each of the following. This is quite a straightforward question. This should not stump us. Okay, Priyanka, Shivani thinks that it is both unsuccessful applications to sue as a pauper and applications to sue as a pauper made in good faith. Let's see. Priyanka, Kanupriya, Ankita, what do you guys think? Shivani is correct. So it deals with exclusion of time where leave to sue or appeal as a pauper is applied for, and then it deals with unsuccessful applications also and applications made in good faith also in its contexts. So Priyanka, if we go through the content of it, it deals with it applies to unsuccessful applications, but also talks about applications made in good faith. So we can see both things being reflected in section 13. Time requisite under the Limitation Act means. So time requisite, the meaning of the phrase time requisite, what is it? Does it refer to minimum time, to maximum time, to actual time taken, or to absolutely necessary time? So, or is it by absolutely necessary time we mean time that cannot be dispensed with? This needs to be done. Which of the following does time requisite refer to? Come on, guys, let's have an answer. I'm beginning the timer. Time requisite. What does time requisite mean? Priyanka thinks it is referring to minimum time. So if we look at the explanation to section 12 and we read it, it says time requisite for obtaining a copy of decree or any time taken shall not be excluded. And by this, time requisite in itself refers to the actual time taken. So the time taken from day one when you're starting some procedure to day for or whenever the ending day when it is ended, when you've sought the document or whatever, that is the actual time requisite, the time you've actually taken up. For claiming easementary right, one must have enjoyed open and peaceful access for a period of, again, a question we should all, as legal pupils, know the answer to. What is the time window for open and peaceful access so that you can claim easementary rights tomorrow? Is it 15 years, 10 years, 20 years, or 40 years? I will begin the timer straight away. This is not something we should need to apply a lot of mind to. So, how can you claim easementary rights? What period of access do you need for that? Again, so easementary rights, you need to have a 20 years, right? You need to have 20 years as a period of enjoying it before you can claim that that is by way of easement that you need that. So, uninterrupted usage of it for 20 years. 3 is indeed correct. Before the expiry of the period of limitation, let's say A has acknowledged in writing the amount due as debt from B, another person B, and B has promised to, and A has promised to pay it. What is the effect of such an acknowledgement? What will happen with such an acknowledgement? Will it have no effect on the period of limitation? Or is it that a fresh period of limitation will start from the date that this acknowledgement is made? Or is it that the period of limitation because of this acknowledgement will be extended for 6 months? Or is it that the period of limitation altogether will not apply at all? Shivani thinks that a fresh period of limitation will start from the date of such acknowledgement. What do the rest of us think? There is an acknowledgement that is being made, right? Before the period of limitation expires, of course. What happens? Priyanka also thinks a fresh period of limitation commences from the date of making such acknowledgement. And that is correct because of section 18. So any acknowledgement made of a liability, etc., a fresh period ensues from the date of such acknowledgement being signed. Limitation for claiming compensation for the act of libel is 3 years from the date when the libel was published. Is it 3 years from the date when the libel published became not of knowledge to the plaintiff, so when the plaintiff discovered such published libel about himself, or 1 year from the date when the libel is published, or 1 year from the date when the published libel comes to the knowledge of the plaintiff, or 1 year from the date of when the damage for which compensation is claimed is caused, or whichever of the two is later. Which of the following could it be? Is it 1, 2, 3, or 4? Please don't mind the letter 5 at the end. It is part of 4 only. So it's either 1 year from the date when the published libel comes to the knowledge of the plaintiff, or 1 year from the date when the damage for the compensation claimed is caused, whichever is late of the two. All right, Shivani thinks it's 1 year from the date when the libel is published only, and Priyanka thinks it is 3 years from the date when the published libel comes to the knowledge of the plaintiff. Let's see which one is correct. And 3 is correct, Shivani is correct. So if you want to sue for libel, right, the limitation period of it is within 1 year from the publication of such libelous material. Okay, Priyanka? So 1 year from the publication of libelous material. Not the discovery, we're not dealing with the discovery, just the publication itself. Limitation for a suit for compensation for inducing the person to break a contract with the plaintiff. So, if there is a person inducing another person to break a contract, then the plaintiff in such a case with whom such contract will be broken off, what is the limitation where he is seeking a compensation for such act? What is the limitation for such suit? It is a bit tricky understanding limitation act questions, but we have to understand a limitation for what kind of suit? A suit of compensation. But against what? The compensation against the other party being induced out of a contract. Now, what is the limitation period here? Is it 1 year from the date of the breach, 3 years from the date of the breach, 3 years from the date when the damage caused by the breach has occurred? So, when the first hit the plaintiff took from the breach of the contract, is it that? Or is it 1 year from the date when the published never mind, this is an incorrect portion. Option 4. Let's treat option 4 as none of the above. So, which of the following will be correct here? This is a mistake, option 4 here. Let's treat it as none of the above. So, is it 1 year from the date of breach, 3 years from the date of breach, 3 years from the date when the damage caused by breach has occurred, or none of the above? I have started the timer. Priyanka thinks it's none of the above. Shivani thinks it's 1 year, and it is 1 year. Again, Article 78. So, if you want to seek a compensation against being induced out of another person being induced out of contract with you, and the limitation period for that is to do it within 1 year from the date of breach of trust. A counterclaim for the purposes of Limitation Act is deemed to be instituted when? Is it deemed to be instituted on the same day as the suit in which the counterclaim is made in the court? Is it deemed to be instituted on the day on which the counterclaim is prepared? Is it deemed to be instituted either in 1 or 2, whichever is beneficial to the defendant, or either as a matter prescribed in 1 or in 2, whichever is beneficial to the plaintiff? So, when is the counterclaim deemed to be instituted? What does the court take as the date of the institution of a counterclaim? Come on, Shivani, Priyanka. I will start the timer now, guys. So, for counterclaims, the correct answer is on the same day as the counterclaim has been made in the court. Yes, 1 is correct. That's correct, UV. I believe my connection was buffering a bit, so I missed your answers. All of you are correct. It is 1 on the same day as the counterclaim has been made on in the court. Where the access and use of light of any building or have been peaceably enjoyed therein within as an easement and as of right without interruption, and for how long, okay, and for dash, and where any way or water course or the use of any water or any other easement has been peaceably and openly enjoyed by any person claiming title thereto as an easement and as of right without interruption as for 20 years, the right to such access and use of light or air or way, water course, use of water or other easement shall be absolute and indefeasible. So, what is the correct fill in the blank for the blank that is stated over there? As of right without interruption and for how long? This is with respect to which of the following? Use of light, air, building, peaceably enjoyed as an easement or and as of right without interruption, but what is the time period that it needs to be enjoyed for in order that it becomes absolute and indefeasible? Shivani thinks it's 20 years. So could it be 1 year, 3 year, 5 year, or 20 years? We have another option answer coming in as well. That is correct. We did hint on it a bit earlier. It is 20 years. Section 25(1) of the Limitation Act states this. Now, in which of the following cases was it held that limitation bars remedy but it does not extinguish rights? Was this stated in the case of Ravindra Grewal versus Manjit Kaur 2014? Was it in the case of Bombay Dying versus State of Bombay 1958? Was it in the case of Gurdwara Sahib versus Gram Panchayat 2013? Or was it in some other case and thus none of the above? Limitation bars remedy but does not extinguish rights. A very important saying that we follow in limitation law. Which case made this insightful comment? I will begin the timer, guys. Come on. The correct answer is Bombay Dying versus State of Bombay. That is what the court stated, that it cannot be, it does not extinguish the right. So if a claim is satisfied outside of the court, it is not illegal. Okay, it is not exactly illegal. So it in itself, it is giving us, it is barring the remedy in itself, but it is not extinguishing the right completely of that person. You cannot extinguish by judicial process, you cannot completely extinguish the other person's right. So if you are satisfying the claim outside of the court, that is not an illegality in the eyes of law. Which of the following would amount to sufficient cause for the purpose of delay under Section 5? So, what can be treated as a sufficient cause for being taken as a delay, a reasonable delay under Limitation Law Section number 5? Is it that the party was imprisoned or was operating under a serious illness? Is it that there was a wrong practice of the High Court involved which has led to a misleading situation for the appellant or his counsel, and thus they have not been able to come up to appeal? Is it that there is a mistake of law in establishing or exercising the right that has been given by law? So the law itself is at mistake, or is it all of the above? We're receiving a few answers. Come on, UV. So it is none of the above, and I'll tell you why. Because the doctrine of sufficient cause, we see that it is under Section 5, but it is a very individualistic text. You cannot establish the grounds for it already, right? So for no two cases can you treat it alike. For no two cases can you elevate two people at the same level and think that their circumstances are alike. So you cannot predetermine what a sufficient cause can be, and you cannot close the doors to what a sufficient cause can be. With each circumstance and with each individual affliction surrounding a circumstance, does the court decide what a sufficient cause can be for any particular case? Yes, Karan, 4 will be correct. And sufficient cause again cannot be predetermined. The court will decide per the matters at its hand. Which of the following is an enabling section? Okay, so there is an array of sections over here in the options, and we have to figure out which belongs where. So section dash is an enabling section to enable persons under disability to exercise their legal rights within a certain time. Section dash supplements section dash, and section dash controls all these sections. A bit complex, but the first fill in the blank should give you a clear answer. So which section enables people under disability to exercise their legal rights under limitation? What is the correct? Okay, Karan thinks that section 6 is the enabling section, and then section 7 is supplementing section 6, and section 8 is controlling all of these sections. Shivani also thinks that. Again, we have discussed all of these sections just before in the previous questions. We must know the answer One is indeed correct. We saw that Section 6 was paving the way for people with disabilities to operate under limitation law. Section 7 was then acting as a supplementary section for Section 6. And Section 8 was again controlling Section 6 and 7, providing us an upper limit as to how much delay can be tolerated in Section 6 and 7. So, yes, one was the correct answer there. The time during which the defendant has been absent from India and from the territories outside India administered by the central government shall also be excluded. This is provided under which provision of Limitation Act? Again, what provision establishes this rule that the time where the defendant has been absent from the Indian territory and has been absent from the territories which are outside India but are administered by the central government shall also be excluded from the limitation period. Come on, guys, we'll have to begin the timer in a while. Is it 15.1, 15.3, 15.4, or 15.5? Priyanka thinks it's section 15.5. And Priyanka is correct. Section 15.5 does read similarly. What is the maximum period of limitation prescribed by the Limitation Act? What is the maximum period provided? Is it 12 years? Is it 30 years, 45 years, or 15 years? The maximum period provided under the Limitation Act, guys. I will begin the timer. Maybe there's a bit of a lag. Okay, Shivani thinks it's 30 years. 30 years is the extent to which the Limitation Act goes. Karan, also that is correct. So Limitation Act does allow for 30 years of limitation. We only have this in three kinds of suits. Suits by mortgages, where you're asking for redemption or recovery of possession of immovable property, or suits by mortgagee, where you're asking for foreclosure, or suits by or on behalf of the central government or any state government. In these, the limitation goes up to 30 years. In which of the following cases was it held that the law of limitation applies retrospectively? Again, a very important conceptual question. It applies retrospectively, but what case held that? Was it the case of BK Educational Services versus Parag Gupta? Was it the case of Thirumalai Chemicals versus Union of India? Was it the case of Excise and Taxation versus MS Frigoglass? Or was it all of the above? Please provide answers in the chat. All right, some of us think it is 1, some think it is 4. Let's see what the correct answer is. I have begun the timer here, guys. And the correct answer is the case of BK Education Services Private Limited versus Parag Gupta. It is actually all of the cases. See, if we go through a reading of all of the cases, option 4 stated all of the above. All three cases led to the understanding that the law under Limitation Act is retrospectively so, right? It applies retrospectively. In BK Education Services versus Parag Gupta, the Supreme Court stated that law of limitation is procedural in nature, right? It is procedural, thus it applies retrospectively. Then in Thermalai Chemicals, the court stated that statutes of limitation are, as far as they apply to legal proceedings after their operations, they for that purpose are retrospective in nature. Then again in Excise and Taxation versus Frigo Glass, Punjab Haryana courts also rule that it is well settled that the law of limitation is as well as procedural and it applies retrospectively unless for the amending statute we are halting its retrospective application. So the correct answer is that all three cases here, again, let's look at the cases, all three cases right here built to the understanding, the jurisprudence that the Limitation Act is retrospective. There is a judicial understanding throughout all these three cases that limitation is retrospectively applied. Maxim interes republicae ut sit finis litium refers to which of the following? Does it mean that it is in the interest of the public to end disputes and legislation and litigation? Does it mean that government, that is the republic, it must endeavor to put an end to disputes and litigation? Does it mean that it is in the interest of the state to end all litigation? Or does it mean that the court must put limits to disputes and litigations in the interest of the republic? So, which of the following is it? Shivani thinks it's that it is the interest of the public to end litigation. What do the rest of us think? It is actually not. That is a common mistake we'll be making, Shivani. See, this is why the options are quite similar. It is not the interest of the public, it is in the interest of the state, not option one. One stated public. Option three is the correct one, state. Right? No, Karan, you were right with three. It is in the interest of the state to put an end to litigation. Again, let's pay attention. Interest, republicia. Republicia refers to the state itself, not to the public. A payment on account of a debt or of interest on a legacy is made before the expiration of the prescribed period by the person liable to pay the debt or legacy or by his agent duly authorized in this behalf. A fresh period of limitation shall be computed from the time when. Is it when the payment was made? Is it when the payment was due? Is it when the payment was demanded or when the payment period expired? So, when will the payment made on account of a debt or interest on a legacy before the expiration of the prescribed period be treated? When will the limitation period be, thought to commence? Okay, I think Shivani and Priyanka answering from the limitation period shall compute, the fresh limitation period computes from when the payment itself was made. Let's see. And that is correct because of section 19, right? So if you have a payment on account of a debt or an interest of legacy, that payment upfront acts as a limitation, fresh limitation for whatever is the remainder of the amount to be paid. It is just the same as we see acknowledgements, right? We saw that acknowledgements also create a fresh limitation period. Consider the following statements about the law of limitation and mark the correct options. So the first statement is that the law of limitation, it does not extinguish substantive rights. The second statement is that law of limitation creates a right in favor of a person, right? The third statement is that the law of limitation bars judicial remedy. And the fourth statement is that the law of limitation is a procedural or ejective law. Now, are only options statements A and B correct? Is it that statements B, C, and D are correct and A is incorrect? Is it that statements A, B, and D are correct and C is incorrect? Is it that statement B is incorrect and A, C, and D are correct only? You may take a while longer to read the statements again, but try to attempt an answer. Yes, guys? What do you think are the correct statements? Shivani thinks that B is incorrect. So the law of limitation is not creating a right in favor of a person, but it does extinguish a substantive right, it does bar judicial remedy, and it is a procedural or ejective law. And Karan also believes in the same. Priyanka, what about you? UV, all right, again, so we see that the Limitation Act is not there to destroy or infringe the rights or create a new right, right? It is a public policy for fixing the lifespan of legal action. It does not want to extend legal action forever and ever, right? So it is to limit litigation. That is what it is trying to do. With that, option B was incorrect, statement B was incorrect, the rest of them were perfectly fine. Section 10 of the Limitation Act does not apply in the case of an executor, a partner or director of a company, assignees for value, or all of the above. Come on, guys. Priyanka, Argya, UV. I want us all to answer. Okay, Priyanka thinks it's all of the above, that section 10 will not apply to executors, partners, directors, or assignees for value. Let's see if that is correct. That is correct. So section 10 does not apply to all of them. Well done, Priyanka. No, Karan. 3 was just the assignees for value. It does not apply to any of those. So whether it is executor, partner, director of company, mm, who are not trustees and assignees for value, they are barred to become trustees basically. So section 10 is outside of their application. Where the prescribed period of limitation for an application is expiring on a holiday, the application should be made on a day prior to the holiday. The application may be made on the day when the court reopens. The application may be made within 30 days of reopening of courts, or the application may be made on any day after the court reopens. Which of the following is the correct legal stance on limitations expiring on holidays? Because these are practical issues and these do happen. So, what does the law provide for in these cases? That the application may be made on any day after the court reopens. Shivani thinks that it may be made on the day when the court reopens, and Priyanka thinks any day after the court reopens. And the correct answer is that it is made on the day when the court reopens, because you have to treat it with a lot of urgency. You cannot wait one other day after the court has reopened. So it will happen just as soon as the court reopens, so the same day. All right, and this is section 4 that is telling us this. Under the Limitation Act, the period of limitation for filing an application for an order to be set aside, for an order to set aside an abatement. So, if you want to apply for an order so that an abatement itself is set aside, what is the limitation period? Is it 60 days from that abatement, 90 days from that abatement, 120 days from that abatement, or is it none of these? The timer has begun. Come on, guys, let's attempt answers. And the correct answer is 60 days from such abatement. Shivani is correct. A borrowed a sum of money from B. The last day of filing the suit falls on a Sunday. On Monday, the next day, that is the next after Sunday, A gives a written acknowledgement to B. What happens in this case? So we already dealt with written acknowledgements. Here, the uh, amount has been, rendered unpaid, and then after the after the expiry of the limitation, the acknowledgement is being made. What happens here? Shall the suit be filed on Monday? Or do we write down that, do we answer with that section 18 of the Limitation Act provides for such circumstances? Or is it that the Limitation Act is barring the suit from being instituted under all circumstances? Or is it that the suit will be filed at any time, just subject to the provisions of section 12 of Limitation Act? Priyanka thinks that the 18th section of Limitation Act provides for these circumstances. And Priyanka is correct. Section 18 does deal with it. So, if acknowledgement is made even of the last date was Sunday, that is a holiday. Now it will be made to be Monday. Now Monday will be treated as the last date. A fresh period of limitation will thus start as per Section 18. A time-barred debt can be claimed as which of the following? As a set-off, as a counterclaim, as a fresh suit, or as none of the above. A time-barred debt. How can you claim it? Ordinarily it will have no legal sanction, right? But if you do want to claim it, can you claim it as a set off, as a counterclaim? Do we have to create a new suit for this? What happens? I have begun the timer. So in case of time bar debts, right? So any claim by way of a set off or a counterclaim shall be treated as a separate suit and shall be deemed to have been instituted. So it itself is treated as a separate suit. So in the case of a set off, where it happens, it is treated as a set off where it happens on the same date as when the set off is, pleaded. And in case of a counterclaim, on the same date on which the counterclaim is not just pleaded but made inside the court, right? So it can be any of the above, basically. 49. Question 49. We have 80 questions in here, so we must pick up the speed a bit, and I'll give a bit of a break after question number 70 so that we have the last 10 questions really to focus on. A stayed in the hotel of B for 1 week. He organized a party for his friends on 1st November 2014, the bill of which amounted to rupees 40,000, vacating his room on 5th November 2014, and settling all his bills except the bill of the party, right? This is what A did. Now, can B sue A for the payment of rupees 40,000? And if yes, when? Will it be done within 1 year from 1/11/2014, 1 year from 5/11/2014, that is when he vacated his room, 3 years from 1/11/2014, or 3 years from 5/11/2014? Which of these can be correct? So let's apply limitation here to the dates and figure out which is the correct one. First of all, we have to determine whether we are dealing with the day on which the organization of party was made, or when he tried to settle the bills and then left. So Karan thinks it is the day of settling the bills and leaving, that is 5/11/2014, and then the limitation period is within 3 years from that exact date. Let's see. And that is correct. 3 years. So here we have to go through to entry number 8 of the Schedule of Limitation Act, and it states that where we are dealing with suits for settling prices of food, drink, etc., kept in hotels, taverns, lodging houses, it is 3 years. And the time is not when it is built, but the time is when it is delivered. So when was the food and everything delivered? On the first only, not the third. The third is when it was built. It was delivered on the first only, so we treat it from the first. The question states itself, the party was on the first, right? So the party was on the first, the food, etc., was delivered on the first, and from there we'll calculate 3 years for limitation purposes. Okay, guys? So these are important cues we need to bear in mind. Section 15 of the Limitation Act excludes from computation of limitation which of the following? Does it exclude period of notice from computation? Does it exclude time required for obtaining consent? Does it exclude time required for obtaining sanction? Does it exclude all of the above? We did see the contents of Section 15 a few questions ago. What was it excluding from the computation of limitation? Okay, I think Priyanka and Shivani think it's all of the above. Okay, Priyanka thinks it is period of notice. No, we saw that it mentioned sanction or consent or period of notice. So it is all of the above. I did read it out loud once before also, Priyanka. So all of the above are excluded. In various cases, you're seeking them, but they're all excluded. A suit on promissory note payable on demand is to be filed within 3 years from the date of note, within 3 years from the date of demand, within 3 years from the date of transaction, or within 1 year from the date of demand. What is the correct answer here, guys? All right, I'll begin the timer. So, suit on promissory note payable on demand is to be filed within 3 years from the date of the note itself. Okay, so from the date of the note itself, not the demand, not anything else, not when it's made payable, but from the date of the note itself. Which of the following will be excluded under Section 14 of the Indian Limitation Act in a case where a formal civil proceeding was pending? So, a case where a formal civil proceeding was pending, and we are dealing with Section 14 for a formal civil proceeding, which of the following days will be excluded from the limitation period being tracked? Is it the day on which the proceeding was instituted? Is it the day on which the proceeding ended? Is it either one or two? Either one of these will be either the day institution or the day of ending will be excluded, or is it that both 1 and 2 will be excluded? Okay, I think Karan is answering with either 1 or 2. I have begun the timer now. Shivani, Priyanka, come on. So it is both, right? The day on which it was instituted as well as the day on which it ended, though those days shall be excluded. The exclusions are inclusive of, no, the exclusions contain, the section says, in excluding the time, the day on which the proceeding was instituted and the day on which it ended shall both be counted. They will be counted in the exclusion. That means they will be excluded effectively. Okay, guys? Don't get confused in reading the Bare Act. They will be excluded. The correct answer is both of these. Look at section 14(1)(a). As per Limitation Act, the term period of limitation means which of the following? Does the term period of limitation mean period of limitation prescribed for any suit, appeal, or application by the schedule to the Limitation Act? Does it mean the period of limitation computed in accordance with the provisions of the Limitation Act itself? Does it mean both one and two, or does it refer to something entirely different and thus none of the above? So the period of limitation means, is it the period prescribed via the Schedule to Limitation Act, or is it the period prescribed in accordance with the provisions of all of the Limitation Act, not just the schedule? Okay, Priyanka thinks it's both A and B. Shivani thinks it is the period prescribed via the schedule. So the official definition Shivani thinks is that the period prescribed via the schedule of the Limitation Act, and that is correct. When we deal with definition portion in section 2 of Limitation Act, and it states that period of limitation, it refers to the period prescribed for suit, appeal, or application by the schedule, right? By the schedule. But prescribed period is what it refers to as a period of limitation computed in accordance with the provisions of the Act. So the entirety of the provisions of the Act, Limitation Act, is described as prescribed period. What is described as a prescribed period there? The schedule specifically is what tells us what the period of limitation should be. Provisions for suits, etc., for which the prescribed period is shorter than the period prescribed by the Indian Limitation Act is contained in which section? So the period prescribed is shorter than the period prescribed in the Limitation Act 1908. Which section of the 1963 Limitation Act contains it? Is it section 28, 29, 30, or 31? Any guesses? Okay, Karan thinks it's section 30, and Karan is absolutely right. Section 30 does deal with provision for suits, etc., where the prescribed period is shorter than the period prescribed by the erstwhile Limitation Act 1902. 1908. Which of the following is a leading case on condonation of delay under Section 5 of the Limitation Act? Is it the case of N. Balakrishnan versus Krishnamurthy, 1998? Is it the case of State of Nagaland versus Lipok? Is it that both these cases, or is it that it's only case number one, that is N. Balakrishna versus Krishnamurthy, civil appeal, 1998? A leading case on condonation of delay, guys. All right, Priyanka thinks it's Krishnamurthy's, and Karan is correct. Both are leading cases on the interpretation of Section 5 of the Limitation Act, right? In both these cases, the court has stated in every case of delay, there can be some lapse on part of the litigant concerned himself. That alone is not enough to turn down his plea and shut the door against him. So we can condone delays. That is what the court was insinuating and stressing on. Under the Limitation Act 1963, in computing the period of limitation for any suit, appeal, or application, the day from which such period is to be reckoned, the day from which such period is to be reckoned may be included, shall be included, shall be excluded, or is it that it may be excluded? Let's pay complete attention to all the terms used here. Inclusions, exclusions, mays, and shalls. What do we think? These terms make all the difference in limitation law, and it's a very practical legal aspect. You have to hone and you have to be very sharp within your brain because you're appearing as judges. You need to practice this religiously. Shivani thinks that such days shall be reckoned. Okay, I have begun the timer. Priyanka, Karan, and that is correct. If we go to 12.1, which deals with exclusions in legal proceedings, it states that the day from which such period is to be reckoned, that day itself shall be excluded from the prescribed from the period of limitation. Now, in computing the period of limitation for any suit, the uh, time during which the plaintiff has been prosecuting with due diligence other civil proceedings, so proceedings aside from this suit, whether in a court of first instance or of appeal of revision against the defendants, shall be excluded where the proceeding relates to the same matter in issue and is prosecuted in good faith in a court, in which from the defect or which from the defect of jurisdiction is unable to entertain it. This portion we already dealt with, so this is a question that must strike our brains immediately. Exclusion of such periods has been dealt with or laid down in which section of the Limitation Act? So these periods that we just read about in this small paragraph, exclusion of these periods has been laid down in which section? Is it section 13, section 14, 12, or 15? Okay, Karan and Shivani think it is section 14. Priyanka, what do you think? What about the rest of us here? Come on, guys. Section 14 does talk about the exclusion of time of proceeding in all these circumstances. That is correct. In the case of suits for compensation for acts not actionable without special damage, the period of limitation shall be computed. So, where there is a case for compensation for acts that are not actionable without a special damage being granted or allowed, what is the period of limitation? Again, you'll have to refer to your knowledge of the schedule of the Limitation Act here. From where it's not just what is the period of limitation, there is a reference point. So from where shall it be computed? Is it computed from the time when the suit is instituted? Is it computed from the time when the suit is accepted by the court? Or is it computed from the time where the injury has happened? Or is it none of the above? Shivani thinks it is from the time where the injury has happened, with for which you will then require a special damage, right? Priyanka also thinks that it starts from the time when the injury has occurred. And that is correct. Section 23, again, you go to section 23, you see that otherwise we see the period of limitation, the exact period in the schedule itself. But for this, for suits for compensation which are not actionable without a special damage, section 23 specifically provides that the period will be computed from and it will commence from the time when the injury has resulted. So we start from that. So Karan, no, not two, not from when the suit is accepted by the court, but from the time when the injury itself results. Time which is begun to run cannot be stopped in the case of subsequent minority, in the case of subsequent insanity, in the case of subsequent idiocy, or in the case of subsequent none of the above. What is the correct answer here? A very interesting question. Time which has begun to run can be stopped in the case of subsequent. All right. Karan thinks it's subsequent insanity. Priyanka, Shivani, it is a disability, Karan. So, time once it has begun to run, right, it cannot be stopped in the case of subsequent disability. Okay, that is the correct answer. So, where once time has begun to run, we go through section 9, right? We go through section 9, where once time has begun to run, no subsequent disability or inability to institute a suit or make an application stops it. So, no subsequent disability will pause a time of limitation that has already run. The expression agent duly authorized in this behalf in sections 18 and 19 of Limitation Act shall, in the case of a person under disability to sign the acknowledgement, include whom of the following. So, if the person is operating under a disability and cannot sign the acknowledgement, so who is an agent duly authorized in his behalf that we are speaking about in sections 18 and 19? Is it his lawful guardian? Is it a committee? Is it a manager? Or is it all of the above? Which of the following is it, guys? I've begun the timer here. There is just a slight delay in the chat. All right, Shivani thinks it's all of the above, and Shivani is correct. Section 20, subsection 1 does state that the expression as used in 18 and 19, the expression agent duly authorized in this behalf includes for the person under disability, it includes his legal lawful guardian, his committee or manager, or any agent duly authorized by his guardian, committee, or manager to sign the acknowledgement or to make the payment that was referred to. A judgment was passed. Again, we have to apply our minds a bit here. A judgment was passed on 10/7/2004. The decree was prepared on 25/7/2004. An application for certified copy of it was made on 26/7/2004, so just a day later. And the certified copy was ready on 1/8/2004. And the delivery of certified copy was taken on 5/8/2004. Now, under section 12, what period will be excluded? Will we exclude the period from 10/7/2004 to 25/7/2004? Will we exclude the period from 26/7/2004 to 1/8/2004? Will we exclude the period from 26/7/2004 to 5/8/2004? Or will we exclude the period from 10/7, the first day, to the 5/8/2004, all of these days? A bit of application required here. Karan thinks we will. Karan, is it that you think that we will exclude period 10/7/2004 through to 5/8/2004? Shivani thinks we only have to excuse the period that was between 26, that is when the certification copy was made, and when it was ready. So the time it took for the procedures to happen so that it could be ready. Shivani thinks that is to be excluded. What do the rest of us think? Shivani is correct. Why? Because section 12 itself provides that in computing the time requisite for obtaining a copy of a decree or an order, any time taken by the court to prepare it shall be excluded. In which of the following cases shall the period of limitation not begin to run? Okay, guys, not begin to run until the plaintiff or applicant has discovered the fraud or the mistake, or could, with reasonable diligence, have discovered it. So, in which of the following cases shall the period of limitation not begin to run until the plaintiff has discovered the fraud or the mistake, or the applicant has discovered the fraud or the mistake, or there was reasonable diligence he could have exercised to discover it? So is it that the it should not begin to run at all, right? From when he could have discovered the fraud, when he could have discovered the mistake, or is it that the knowledge of the right or title on which a suit or application is founded is concealed by the fraud of any such person or a aforesaid person? Is it that case? Is it that the suit or application is for relief from the consequences of a mistake, or is it any of the above? In the existence of which of these circumstances will the period of limitation not run? Will it not run simply where the discovery has been done or the discovery could have been done, right, with reasonable diligence? Will it not run where there was knowledge, right, or there was concealment? Will it not run where the application itself is for relief from the consequences of a mistake? Okay, I believe Shivani and Karan are answering for either of the above, and either of the above is correct. So as we go through section 17, all three are stated within it, right? So in all these cases, the period of limitation will not run where it is based upon fraud, where there is knowledge that there is a concealment, where there is knowledge that it is wholly and solely based upon fraud, right? Or the suit or application is for a relief from the consequences of mistake. In these cases, the limitation period will not begin to run itself. What is the remedy provided in the Limitation Act if the writing containing the acknowledgement is undated? An eyewitness of the same has to submit his statement in writing. An approximate date of the acknowledgement is taken. An oral evidence may be given of the time when it was signed, or there is no remedy provided under the Limitation Act. Which of the following is the correct answer here? The question is, what is the remedy provided in the Limitation Act if the writing containing the acknowledgement is undated? An eyewitness of the same has to submit his statement in writing. An approximate date of the acknowledgement is taken. An oral evidence may be given of the time when it was signed, or there is no remedy provided for the same under the Limitation Act. Okay, oral evidence may be taken of the same is Shivani and Karan's answer. Priyanka as well, and that is correct. If we go to section 18.2, so where the writing is undated, oral evidence does suffice as for when the time of signing was, right? A judgment creditor can apply for extension of period of limitation in case of fraud or force by judgment debtor. However, this application has to be made within a certain period of time from the date of the discovery of the fraud or the cessation of force. What is the prescribed time period in the Limitation Act for the same? Is it 1 year from such discovery or knowledge? Is it 2 years? Is it 3 years? Or is it 5 years? The extension of period of limitation where the judgment debtor is using fraud or force. Shivani thinks it's 2 years. I will begin the timer. Come on, guys. Priyanka as well. It is 1 year. See, guys, if you look at 17.2, the proviso to it provides that it is such application shall be made within 1 year from the date of discovery. We were talking about the date of discovery of fraud or the cessation of force. So it is 1 year from that period. From when is the period of limitation computed if the right to institute a suit accrues only on the death of a person? So, is it from the death of the person? Is it from 1 year of the death of the person? Is it when a legal representative is legally appointed? Or is it when the legal representative is capable of instituting the suit? So this is in respect to right to institute a suit which only accrues on the death of another person. Priyanka thinks it is that when the legal representative is capable of instituting the suit. That is when the limitation period will start. What do the rest of us think? Is it perhaps since the death of the person or 1 year after the death of the person that we have to, wait? Or the legal appointment of legal representative that we have to wait for? Shivani also thinks that it is when the legal representative is capable, and that is correct. Section 16.1 does provide for it. So, when the legal representative of the deceased person is capable of instituting such a suit or making such an application, does this limitation period commence? Now, we have two statements of which we have to pick out the correct ones, or if possible, both can, or if we think best, both can be incorrect. Let's see which one is which. So statement A states, in computing the period of limitation for any appeal, the day from which such period is to be reckoned shall be included. Statement B states, in computing the period of limitation for any appeal, the day on which the judgment complained of was pronounced and the time requisite for obtaining the copy of the decree shall be excluded. Is statement A correct? Is statement B correct? Are both of the statements correct? Or are both of the statements incorrect? What do we think? I will begin the timer now. So statement B was correct and statement 1 was incorrect, right? Statement B was correct in light of section 12, which we have already discussed so many times now. Question number 67. Limitation Act is applicable to which of the following? Again, a conceptual question. Does it apply to criminal proceedings, to civil proceedings, both civil and criminal proceedings, or does it apply to writ petitions only against executive actions? All right. Karan thinks it's apply to both civil and criminal proceedings. Priyanka thinks only civil proceedings. I have begun the timer. This is limitation, Karan. It won't apply to criminal proceedings. Criminal proceedings cannot be put a limitation on. This is for civil litigation, right? Litigation is different from criminal proceedings. Again, limitation act applies to litigations, right? So they ordinarily, the proceedings here, the provisions here apply to civil cases to limit litigation, but you don't want to limit criminal litigation. Criminal litigation happens because of violation of rights, right? So things you need to suppress, you want to address that and not shut that down. You don't want to limit those rights. So ordinarily the limitation act will only apply on civil cases, right? So the correct answer is 2, as Priyanka answered. The limitation period for setting aside an ex parte decree is 7 days, 14 days, 30 days, or 60 days. Setting aside an ex parte decree. Your timer has started. Ex parte decree limitation amount is, and Priyanka is correct. The limitation here is 30 days. Okay, from the day when such application commences, from the day of decree, or from when summons was not duly served, etc. Right. So the setting aside of a decree ex parte is 30 days from the date of such decree. Then you can set it aside. Legal disability clause, as provided under the Limitation Act, is applicable on which of the following in which of the following cases? Does legal disability apply on someone who is terminally ill, or a person who is falling below the poverty line, or a person who is a child in the womb? Is that a legal disability, or is it none of the above? What is the legal disability clause? I've started the timer. What will it be applicable on, guys? So we see that as it describes a minor, it does include, the explanation states that it does include a child in the womb, right? So legal disability means a child in the womb, because of which option number 3. Priyanka, not 4, 3. Looking at the explanation of section 6, a child in the womb is a minor and thus under the ambit of legal disability. Which of the following includes a right not arising from contract by which one person is entitled to remove and appropriate for his own profit any part of the soil belonging to another, or anything growing in or attached to or subsisting upon the land of another? So, which of the following is a right? Is it easement that allows you to do that? Is it a promissory note that allows you to do that? Is it a period of limitation that allows you to have such a right? Or is it a bill of exchange? What kind of what kind of power is giving you a right that is generally not arising from contract, but you still have this right to be entitled to remove and appropriate such a thing for your own profit? Shivani thinks it's easement. I have begun your timer here. That is correct. Section 2F does state that easement, it defines easement in the same manner. Now, we'll take a brief break after this question and then we'll discuss the remaining 9 questions. Section 22 of the Limitation Act refers to which of the following? Now, what does Section 22 deal with? Does it deal with continuing breach of contract, successive breach of contract, both continuing and successive breach of contract, or does it provide for special damages? Section 22. All right, continuing breach of contract is Priyanka's answer. And that is correct. Continuing breaches in torts and contracts is what Section 22 deals with, and it starts with every continuous breach, a fresh period of limitation commences or begins. So, guys, let me know how everything is so far. How do you feel? Are there concepts and limitation that you feel like you need to revisit now? Because that is my aim. There should be a certain level of confusion that comes across your mind with this quiz, so that you go back to those provisions. This should point you towards your weaknesses and concepts you have misunderstood, right? So it acts as a fact checking mechanism for your brains as well. So tell me, are you taking the MP quizzes, and how is the general? Because it's not a long, long way away, the MP prelims. We don't have months. We barely have a month here for the MP prelims to happen. So are you adopting successful strategies? Are you taking mocks? From my end, the mocks being taken, the marathons being taken, the quizzes being taken in time is the best strategy you can have. So this is just for you to test your existing knowledge. Anything that you answer incorrectly, anything that you mess up with on mocks or marathons or quizzes is something you should note down, go back to and perfect the concept, and then come back for another mock and not let anything weigh you down. Because the worst that can happen is you will answer it incorrectly, but you also immediately learn that, hey, I was wrong, and you fix it, right? So this is a mistake that can happen here, and we welcome such a mistake here. But by making that mistake here, you avoid the heavy cost of making it on the day of the prelims. So just let me know how your scores have been so far in the MP prelims mocks, and how it has been, how the questions have been. Just to let you know, I am the mocks team head. So if you have any issues with the questions in the mocks themselves that you attempt in the day, that are live in the day, you can let me know. You can reach out to me directly and I'll help you out. Okay, guys, I will begin the next few questions shortly and we'll finish by 9. So, this is question 72. The general rule is that the law of limitation only bars the remedy but does not extinguish the right itself. The exception to this rule is contained in which of the following? What contains the exception to this general rule? Is it section 24, section 31, section 29, or is it section 27? Shivani thinks section 27. I'm starting the timer. That is correct. The general rule is that it does bar the remedy but does not bar the right itself. But with 27, we deal with adverse possession, right? So section 27 states that at the determination of the period hereby limited to any person for instituting a suit for possession of any property, his right itself to such property shall be extinguished. So it goes to the extent of stopping that right. Any appeal or application for which the period of limitation is shorter than the period of limitation prescribed by the Indian Limitation Act 1908 may be preferred or made when? Within a period of 90 days, next after the commencement of this act, within the period prescribed for such appeal or limitation by the erstwhile Limitation Act 1908, either A or B, whichever period expires earlier, or either A or B, whichever period expires later. A very important question. What happens when the limitation period is shorter than the limitation period in the earlier act? What commencement is picked? What is the actual limitation period we go for? Priyanka thinks that it is within a period of 90 days next after the commencement of the Fresher Limitation Act. And the correct answer is 30. It is taken as whichever of the two expires earlier, right? So whichever of the 1908 or the newer Limitation Act period expires earlier, happens sooner, that is the period of limitation that we go with, Priyanka. Okay, so not the period of limitation of 90 periods after the commencement of the Fresher Act. No, that is a very short lived period of limitation. Whichever expires later of the two period of limitations prescribed, that is what we go for. Next question. Under the Limitation Act, the period of limitation for filing a suit for compensation for false imprisonment begins to run from what time? Does it begin to run from the time when the imprisonment ends, or from the time when the imprisonment begins, or from the time when the prosecution is terminated, or none of the above? I have begun the timer. Come on, guys. False imprisonment cases. What is the Karan thinks it's from prosecution being terminated. No, it is Article 73 provides that it is when the imprisonment ends. So only when the imprisonment ends do you file a suit for the compensation. So Priyanka is correct. Only when the imprisonment ends. Article 73 deals with that. Section 21 of the Limitation Act does not apply in which of the following situations? Where you are adding a defendant for the first time, where you're substituting a new plaintiff for the first time, where the roles of the parties are reversed now, or where you're adding a new plaintiff for the first time. Not substituting, but adding a new plaintiff for the first time. So when in which of these following situations does Section 21 of Limitation Act not apply? What do you guys think? I have begun the timer. Karan thinks when you are adding a new plaintiff for the first time to the suit. And it is when you are substituting or adding. It is option 3. Yes, option 3 is correct. So, as we see, section 21, which deals with effect of substituting, adding new plaintiffs or defendants, it states that where after a suit is instituted, then you are putting in new plaintiff or defendant, whether you are substituting them for an earlier one or whether you are adding them. The suit, as regards to them, will be have to be made from the day when he was a party, right? But the proviso to it does state that when the court is satisfied that the omission to include this new plaintiff from the beginning was because of a mistake of good faith and you didn't do it on purpose, only then can you allow it. The court cannot allow you to keep on adding new plaintiffs, new plaintiffs, new plaintiffs, so that a new date of institution of suit is allowed. No, that is not how it happens. And then subsection 2 does provide that nothing in subsection 1 applies to a case where a party is added or substituted due to assignment or devolution of interest during the pendency of a case, or where the plaintiff is made a defendant or a defendant is made a plaintiff. That means where there is a reversal of parties. So in those situations, subsection 1 will not apply. So the reversal of parties is not an application of this subsection here. Now, again, we are dealing with two statements. The first is law of limitation is an adjective or procedural law. The second is law of limitation creates a right in favor of a person. Is B right and A incorrect? Are both B and A correct? Is A partially right and B completely right? Is A correct and B wrong? What do we think, guys? Again, we should know the answer to it. Again, a very common concept that should be clear in the law of limitation. Karan thinks A is correct, B is wrong. Priyanka as well. And that is right. Again, as we discussed, it is not creating a new right in favor of any person. It is not defining a new cause of action, etc. It is only prescribing a remedy. The period of limitation for a suit for an account and a share of profits of a dissolved partnership firm is 3 years from when? 3 years from the date of the partnership, 3 years from the date that the share of the profits is denied to a partner for the first time, 3 years from the date of dissolution of partnership, 3 years from the date that the partnership refuses to give accounts to the other partner. When does the limitation period for recovering account or sharing of profits of a dissolved partnership commence? Is it from 3 years from the date of partnership itself, or 3 years from such a denial, or 3 years from dissolution of partnership, or 3 years from when the partner is refusing to give accounts or share of profit to the other partner? Okay, so we think it is 3 years from the dissolution of the partnership that the limitation period commences, and that is correct. Article 5, if we go through the schedule, in Article 5 itself does state that the suit for accounts and share of profit of dissolved partnership firm will be done in 3 years. That's the limitation period, but 3 years from the dissolution of the firm. As per Section 2C of Limitation Act, a bill of exchange includes which of the following? Does it include a promissory note and bond? Does it only include a promissory note? Does it include a hundi and a check? Or does it include just a bond? What do we think, guys? What is included in a bill of exchange? Karan thinks a hundi and a check are in a bill of exchange. Priyanka, Shwani, that is correct. Section 2C does provide that bill of exchange includes a hundi and a check. Section 2J defines prescribed period, period of limitation, both A and B, or does it define good faith? 2J. Come on, guys, we only have one more question after this. All right, both A and B, and that is correct. Period of limitation as well as prescribed period, both of which we discussed, are provided in Section 2J of the Limitation Act. No, no, not just prescribed period, Priyanka. 2J provides for both. What is the period of limitation? We saw that the period of limitation is provided in the schedule. Prescribed period is provided in the provisions of the Act. Last question. The trustee, as defined under Limitation Act, will not include whom of the following? Will it not include a benamidar? Will it not include a person who is in rightful possession with title? Will it not include a mortgagee in rightful possession? Or will it not include all of the above? For the purpose of Limitation Act, who is not a trustee? Karan thinks none of these are trustees for the purpose of Limitation Act, so they are not included. Shivani as well. Let's see the correct answer. Priyanka as well. So it is one only because it does explicitly provide that trustee does not include a benamidar, right? And a mortgagee remaining in possession after the mortgage has been satisfied, or a person in a wrongful possession without title. So options B and C are not entirely incorrect, but benamidar is exact wholly and solely removed from the ambit of a trustee. If you go to 2N, we see that the trustee is not inclusive of benamidar, not inclusive of a mortgagee remaining in possession, but when? After the mortgage has been satisfied, or a person in wrongful possession without a title, right? So pay very close attention to the options available. You are dealing with what is not included. That was a person in possession with title. That is not a person who can be excluded from the ambit of a trustee. So make sure you're reading the options correctly. That is the mistake we made here. So trustee, we only need benamidar. A benamidar automatically will not be included as a trustee, but then a mortgagee remaining in possession after the mortgage has been satisfied is a person who will not be a trustee, and a person in wrongful possession without title, not with title. A person in wrongful possession without title is a person who shall not be a trustee for the purposes of the Limitation Act. So I hope that was helpful. Let me know in the comments how beneficial the quiz was, and if you have any doubts, and how many mocks you are attempting and how the mocks are going. I am hopeful that you will continue to attempt the marathons coming up. You will continue to attempt the mocks coming up as well as the quizzes coming up. And there will be further quizzes along the way. Make sure you are tuning in for the quizzes. If you happen to miss a quiz, a marathon, they will be available on the YouTube channel later on. But I would encourage that you take them on time. Yes, this is game over, but actually not game over, Karan, because we have a lot to do, a lot to accomplish. So let's keep the spirits high. And even if you get all the answers wrong, no problem. There's always room to learn, right? And you can always improve on concepts. That is the ultimate aim. So keep trying, keep working hard, and only the best will come to you. Take care, guys, and have an excellent night. Make sure you are attempting all of your papers, all of your mocks. That is truly essential to your success for the MP Civil Judiciary Services, because you will come across questions that will be in your paper. I assure you that we have an excellent streak of common questions with the actual prelims papers. Just recently, we did a 52% similarity we had with the JKPS and JKCJS paper. So we have similar along the ways. In some papers, it goes up to 72% similarity. So 72 out of 100 questions we have already shown to our students. So make sure you're not missing a single question in the mocks. You don't know which question you're coming across will be in the paper tomorrow. So take the mocks, take the marathons, take the quizzes, and all you have to do after that is succeed. So take care, guys, and have an excellent night. Rest well and come back tomorrow stronger. Goodbye.